Good afternoon, everyone. Thank you for joining us. We'll get started here in just a few minutes. I see a couple people still logging into the call, but once we slow down, we'll just jump right into it. First, as always, thank you. We're looking forward to doing this call, and we'll introduce our special guest here in just a moment. As a reminder, you can chat by going to the bottom of the screen, click the button chat with us, raise your hand, and we'd be happy to unmute you and let you ask questions that way. But before we get started, of course, Dave, please take over and have a few comments, I believe.
Okay, great. Well, thanks again, everybody. First of all, I want to say this. If you have any other topics you want us to touch on with other professionals, maybe accounting, things like that, we want to know how this goes in your mind. Do a little different than focusing on finances. So, well, it is focusing on finances, but the market's setting that aside for right now. So we want to hear from you as well about this, because it's our first run with using some outside folks, right? Or outside the expertise that we've had with money managers, say, okay? But I wanted to point this out because I think it's always, I can't help it, I like to have little lessons in there. And we just went past Dow 30,000, as you know, and you couldn't miss that. And if you didn't catch our Zoom call, we want to let you know we're out there on YouTube now. So, and we've had good feedback from that. It's a great story of our lifetime. So go out to YouTube, Petso Financial, and click on that one. And we also encourage you to subscribe, because then you'll get alerts if we do something and you were unable to catch it. But I wanted to point this out because this is one of those things that we miss in the day-to-day worries. We have a big runoff election coming in on January 5th. Ooh, the market's going to be higher or lower. You'll hear all kinds of commentary about that. But one thing you heard all about was how you had to be out of the market for this election because Joe Biden could win. And it appears he did. So why didn't the market tank? That's kind of a separate issue, but again, it says that the market is doing what it's going to do regardless of what you think or what your political beliefs are. And the number of iPhones that Apple sells next year isn't going to change whether Joe Biden was elected or Donald Trump was. And we forget that. Companies innovate and change. Does it matter to the economy? Certainly in long term, but individual businesses is what you're buying with the market, and we forget. I just want to mention this because in the height of doom and gloom, back in March 23rd to be exact, to today, the market is up, as measured by the S&P 500, 67%. So now, if you think things are getting better, what did you miss? Everything. 67% is, well, usually about 6 years worth of returns. It's a lot. And that's how the market does it. And it does it at unexpected times. It certainly didn't happen on March 23rd when it bottomed because, well, COVID was over. All the worst was behind us. It wasn't. Things change, and they change rapidly. And we just have to sometimes set it aside and say, there is a certain amount of faith that the world will continue no matter who is in office, no matter what's going on in the economy. 67%. I had to run the numbers today because I thought that was astounding. But we see this all the time in our march to Dow 30,000. Now with that, I'm not here to talk about a lot today. We're here to talk about estate taxes and answer your questions. I'm going to hand that back to Jennifer to introduce our special, she's my attorney as well, and also Sandra Clapp. But Jennifer, take it away from here.
Absolutely. First, thank you again for all joining us. Sandra, I worked with her probably now, I can't remember not having worked with her. She's been an amazing resource to us. She helps us when we need special circumstances with clients that have come up over the years. But overall, she is really the expert on estate planning. We feel that strongly. We know that when it comes to, do you need a trust, do you not, what special things that do come up as you're trying to plan out your estate and things that come up after you pass. She's just great. So I'm so thankful she joined us today. Again, I'm going to be quiet and let her take over, but if you have questions, raise your hand. We can unmute you, send us a chat. She's open to anything, so please don't hold back.
Well, thank you both Dave and Jennifer for the opportunity. And likewise, I thoroughly enjoyed working with the two of you. You provide wonderful service to your clients. And as Dave and Jennifer mentioned, well, I'm here to answer your questions. I'm here to give you guidance. I want to make this as helpful for you as possible. So to segue off of what Dave was talking about with the election and what's happening with the markets, in the estate planning world, we also were very carefully watching over the last, probably I started watching well over a year ago, about the political scene in the federal government and what's going to happen with the estate tax world. Now that we have the election resolved, other than the Senate, which we still are waiting for that outcome, in my world, there's concern about the estate tax laws changing from the current exemption amounts. The current exemption in 2020 is $11.58 million per person. So between a husband and a wife, that's about $23 million of assets that can be transferred free of estate tax, at least in Idaho, and some states have their own state level inheritance or estate tax that do need to be factored in. We know that in 2026, commencing January 1, that exemption will go back down to a $5 million indexed amount. The concern among estate planners is if the power structure changes in Washington through this election process and the Democrats take control of House, Senate, and the presidency, that the exemption amounts may go down more rapidly than 2026 and even lower than the $5 million indexed amount. So at this point, it's anyone's guess about what Congress will do and what will actually happen. But in the event you have significant wealth, you have really until December 31 as a bit of a safety net, that if you're thinking about making larger gifts, you may want to consider doing that sooner rather than later. We can wait until 2021. The concern would be in the event Congress does end up putting this on the agenda and bringing this forward in 2021, it would be a retroactive tax to January 1. So it's a bit of a gamble either way, but I would encourage you, if you are concerned about estate taxes and you have resources that you're going to potentially have be subject to estate tax, consider whether gifting in 2020 would be helpful. And I know that Dave and Jennifer are going to do a little bit of a question and answer, but some of the topics they wanted me to touch on, and I'll just kind of jump into one of those, is the difference between a will and a trust, and then I certainly open it up to your questions. There's been discussion about, do I need a will? Do I need a trust? And I wanted to give you a little overview about what the probate process entails and when a trust can be beneficial. If you are a resident of Idaho, we have a very simple probate process. So many times we will just use a will because it's the simplest. If you live outside of Idaho, your decision on a will versus a trust is going to be state specific because every state has its own probate and every state's laws are different. And I do pick on California a little bit because their probate is extremely cumbersome and extremely costly in my experience. In that jurisdiction, you would want a trust. What a trust will do is it comes into effect today, so the trust is actually signed, and assets are moved into the trust by legal title. Real property is transferred by name into the trust, accounts are put into the trust, and because those assets are controlled inside the trust, if a death occurs, we aren't subject to the requirement of the court validating the will because the trust already controls and holds those assets. Where a trust in Idaho is helpful is if you do have out-of-state real property. So you have a vacation home in some lovely warm climate. If you think you're going to move from the state, or you start spending significant amounts of time in other jurisdictions, anytime you start touching other states in a material manner, buying property, even spending time or rentals or accounts, then it's time to start thinking about, would a trust be more beneficial? The decision is not cookie cutter, it is state specific. So get some guidance on what works best for you, how committed you are to maintaining the trust, how much work is that going to entail. Some of my clients just say, I'm not going to do it, I don't care. And just get good guidance on what works best for your personal situation.
Good. Sandra, can you maybe elaborate a little bit for us on the trust situation? I'm going back a few years now, but I remember hearing from an estate planning council that some number like 90% of the trusts that are written in Idaho are unnecessary. And we see that where literally legal organizations, attorneys, groups believe that everybody, even if they have a simple IRA with a beneficiary designation, in other words, no assets to do anything with, are putting people in trust. And it's very expensive, cumbersome. It's kind of like stealing from old people. And I just want to get your handle on that. If you could maybe elaborate just a little bit more on that, and how in Idaho it is different than maybe in other states.
And I certainly don't want to disparage my professional colleagues, but I likewise have encountered the same situation where trusts are being really overused in places where it's just not necessary. So in Idaho, let me just give you what that probate process entails. If you passed in Idaho either without a will, and that's called intestate, or you died in Idaho with a will, the person who is going to be the personal representative, and that's the executor, the administrator of the estate, they sign pleadings representing to the court your age, your date of death, your residency, whether or not you had a will, and if you have a will, submitting that to the court, the individual accepts the position and accepts the jurisdiction of the court. A few days later, the court issues what are called letters testamentary, and it's basically the court's affirmation and grant of power to the individual who is going to administer the estate. From that moment on in Idaho, the court does not get involved. There's no mandatory approvals. In either the trust or the estate through the probate, there's going to be a process of inventory of assets, payment of debts and expenses, liquidation. That's going to happen either place. So having a probate is not going to change the administration steps. In states, however, like California, everything must be approved by the court. So any action taken, there's a court moderator to that monitors the estates. There's compensation that's based upon a percentage of the estate. So the attorney, personal representative, everybody involved in the estate gets a percentage of the estate. Idaho does not have that. We have simply reasonable compensation. Again, it's unsupervised, so the court expects that the person who has accepted that responsibility acts properly and prudently. Now, if that individual does not act properly, the court's jurisdiction is still there, and matters can be brought before the court for resolution, whether it's a creditor claim, removal of the personal representative, accounting disputes. So it's not that the court's jurisdiction is unavailable, it's just not forced upon the estate during the administration process. So in most situations, again, the highlights that I raised before, if you have no out-of-state real property, so no home, no real property outside the state, and you're really not planning to move, a will is oftentimes just the simplest, because we put it into effect, we check your title just to make sure that we don't have any unexpected outcome based upon titling. We check beneficiaries to make sure it flows the way that we want it to flow. And it's less administration going forward. So these groups that are oftentimes promoting trusts don't recognize or don't maybe acknowledge that the probate process in conjunction with the will is probably less expensive and less burdensome to the individual, because unfortunately in some of those situations the intent is to, I think you called it robbing from old people, and unfortunately it is, because there's scare tactics that are used, marketing ploys, information that is not accurate in Idaho. And this touches again on the fact that every state is different. So if you were to take a story from California and try to relate it to Idaho, the same facts and circumstances could play out very differently. So as you make these decisions, I would encourage you to consider, am I going to stay in Idaho? Do I have multi-state activities? Do I live outside of Idaho? And if that's the case, then possibly a trust is appropriate. But in Idaho, as an Idaho resident with Idaho located assets, you really don't need a trust.
Can I ask one other question regarding that, though? Because we get this type of question often. Doesn't a trust provide some legal certainty against lawsuits and things like that? And I step outside of my legal expertise to answer that question, but I think people would rather hear from you.
Oh, I thank you. I hear that a lot about a liability protection. Well, if I put it in the trust, I don't have to worry about it. If I go into a nursing home, they can't count it. Creditors can't come after it, and that is not true. A standard revocable trust, it has no liability protection, no tax protection, no creditor protection. It does not accomplish any of those steps, because a revocable trust by its terms is your property. You can revoke it, you can terminate it, you can change it. Because of that authority, the law treats it as your property because it's yours and you control it and you benefit from it. So because it's in essence your property, the trust facade isn't going to create any kind of legal protection over those assets as far as, again, liability protection, Medicaid qualification, creditors. It's just not going to create that kind of protection. To do that, you really need more of an irrevocable trust. And that's a whole different creature than a standard revocable trust. You give up control, it becomes a tax entity. There are certain state requirements depending upon the jurisdiction for that to be removed from your estate. So, a trust doesn't really create any level of protection. And with regard to litigation or disputes among even heirs and family, no. If we're going to have a family feud, we're going to have a family feud. It's just whether it's the trust or whether it's the will.
Exactly. Good. Go ahead, Jen.
All right, so I want to kind of sort of tag into this a little bit. A lot of states, we have Erica who joined us from Cleveland, and they were allowed to put pay on death or transfer upon death designations on homes. I don't believe you can do that in Idaho. Is that correct?
That's correct, except between a husband and wife. So if it's a husband and wife, we have a statutory process that's identified as community property with rights of survivorship. So a lot of times if we're planning with again, let's kind of go down to the fundamentals, we're just going to have a will and it all goes to the surviving spouse. And a lot of times I will couple that with this change of titling on the real property to tack on community property with rights of survivorship. So in that case, on death of first, all we do is we record the death certificate with the county where that real property is located, and by operation of law, it transfers to the surviving spouse. So in some situations in Idaho, we actually don't even have a probate on death of one of the spouses if we have beneficiary structure and everything going to the survivor. That does not work right now with any person outside of a husband and wife, and we just don't have a statutory process to have joint tenancy with kids or pay on death with kids. We've ended up in some quiet title actions because people have done that without legal counsel. Maybe that will change in the future, but right now on real property, that it only works between husband and wife.
Okay, good. We have a couple questions from clients because they are about trust, so we'll stay on that topic and then we'll switch over. First one, what about a trust for managing assets after death, i.e. for children until they're older?
Mm-hmm. No, absolutely. I think that's, the term trust is generic. And so sometimes we kind of use the term trust, but it could be an irrevocable trust, a revocable trust, a charitable trust. So really to understand trust, it's a relationship between the creator of the trust, the trustee, and the beneficiaries. And then the format can be different. So a trust for a child, absolutely beneficial, I think very appropriate for minors or young heirs. And that type of trust can be created either through a will. If it's created through a will, it would say, for example, I give my estate to the trustee to administer for my daughter, Gretchen. The trustee is named in the will, the terms are outlined in the terms of the will, and that's called a testamentary trust. That trust, again, is not established until the death occurs. The will is probated. The trust is then created through the will. If we use a revocable trust, and that's the trust that I was kind of touching on as far as a planning tool, that revocable trust can likewise divide out into different trusts. It could divide into a trust for a child. It could go into a charitable trust, a trust for a spouse. The type of trust is dependent upon the terms. So a trust for a minor, very beneficial. I would highly recommend it just to make sure that you have a training tool for those young beneficiaries. You protect them from influences young relations, or the fact that they're even under age 18. Legally, they can't inherit.
Okay. How often should a trust be periodically reviewed by an attorney? If so, how often?
Very excellent question. I do recommend a review about every 3 to 5 years, and that's just to review, to check on who are the fiduciaries, are they still able to serve, is that still who I want? To me, the real key to any estate plan are the fiduciaries, and that would be the executor, the administrator of the estate, the trustee, the powers of attorney for healthcare, the power of attorney for financial affairs. Those people are absolutely key to the success of the documents. And so I do recommend that if you have a significant family change, an illness, a death of a child or beneficiary, something that happens that really is material to the family or the people you pick, come in sooner or go review it sooner than the 3 years to make sure that it really functions. I think the tendency for a lot of people is to put the documents into place, stick them in a dark drawer somewhere and not look at them for 20 years. And the challenge with that is the law changes. The tax laws change, the state law change, families change, people change. And if that document is not evolving with the law and life, it may be unworkable at the time. It may just be cumbersome and not necessary. I find in a lot of old documents today, anything from probably, say 15 or so years ago, there's a lot of estate tax trusts and planning built in that are just not necessary because our exemptions are so much higher. And when they haven't updated the documents and the trust says, you will fund the credit amount into this bypass trust, we don't have any choice. That's what it tells us to do. And that's what the decedent instructed. So short of a court order with a modification, what's called a TEDRA agreement where all the beneficiaries agree, without some sort of legal adjustment, we must take that bypass amount, which now is 11.58 million. So we could take, sometimes up to half of the estate and move it into this irrevocable trust where the estate may only be $2 million. They just may not need that. So kind of rule of thumb on review, 3 to 5 years, unless you had a significant change in family or asset circumstances.
Okay, so the last one up here right now is, what if the attorney who developed your trust moves to another firm? Should we stay with the original firm or follow the attorney who developed the trust?
A good question. I look at the attorney relationships as personal relationships, and it's not cookie cutter. Like I say, every attorney and professional brings their own skill set, just like Jennifer and Dave bring their own skill and personal ability. I think the same of attorneys. And I would look at, are you comfortable with the attorney who prepared the document? Do you feel like that attorney was competent, understood your needs, responsive to your questions? If that's the case, then I would probably follow with the attorney. If you felt like really it was more of a firm effort and you didn't have necessarily a rapport or a connection specifically with the attorney, then maybe you stay with the firm and not follow because it does take effort to move the file.
We run into, from time to time, a circumstance where somebody is trying to find a trustee. It's difficult for us to act in that capacity, as well to help somebody be the executor. I lost my word there for a minute. Corporate trustees are notoriously cold, impersonal, and incredibly expensive. They're poor administrators, blah, blah, blah. That just seems to be across the board. Bank trustees are expensive and terrible. What do you suggest to clients when you just don't have somebody to take that role within the family, or you really as a successor because people die? What do you suggest happening there?
Excellent question, and kind of plays into my earlier point that those fiduciaries are just so important to the success of the plan. So picking an unqualified family member to me is not the option, because we're going to end up with bigger problems than payment of fees to a professional. So we're always weighing the pros and the cons of who do we have available. I encourage the clients to look around them first. Family, friends, do they have advisors who could potentially serve in that role? Some accountants will serve in that role. Maybe they have professional colleagues that they would feel comfortable with. If we look around at the individuals and we don't find anyone that they are either comfortable asking, because it is a burden, it is a job, it's a responsibility. So if there is no one on the individual level, then we would look at corporate fiduciaries, and that can be either traditional banks, or there are several private fiduciary companies, at least in the Boise area. One is called Northwest Trustee Management, another is Trust and Estate Services, and there are some others as well. Those private fiduciaries are trained trust officers, trained professionals, but they don't have necessarily the limitations and fee schedule that say a bank would. So I think it really depends on what needs the client has. If they have very, very complicated assets, let's say oil and gas interests, or something that's even a hard asset to understand, maybe intellectual property, sometimes it's best for us to use those corporate professionals if they have specialty in those asset classes. I have some clients with a lot of oil and gas, and we use a company out of Texas because that firm has specialized knowledge in that asset class. But that's the $1 million question right there.
Yeah, that's tough. Yeah, there's no question that people are, we all want to do the right thing with money, even beyond. But there are a number of limitations to, if you will, managing your estate from the grave.
Very true.
Yeah.
So we had a question come up with a client that had a power of attorney, but it was a springing power of attorney, and they didn't understand the difference. So they wanted someone to, I believe it was a daughter-mother relationship. She wanted her daughter to be able to act when she was gone on vacation or taking a trip somewhere, but we couldn't honor it because there was no qualifying event. Can you explain the difference to people?
Sure. So a power of attorney, and when we use the springing clause, usually this relates to a financial power of attorney. So a power of attorney that relates to assets and financial management. The power of attorney is intended to allow the designated agent to make whatever financial decisions are granted, and usually it's a very broad scope of authority, not so limited, but usually fairly broad. That agent is given the right to manage the financial affairs. The springing clause, it's an old-time common law English rule where basically the power is signed, but the authority is dormant. So the agent can't act until the condition is met, and then the power springs into effect. That's the idea behind it. Most of the time, the springing clause or the springing limitation is a capacity determination. And depending upon how it's written, it could require 2 medical physicians, it could require a committee decision, but the clause is intended to limit the ability of the agent to use the power until the condition is met, normally a capacity determination. So when we're talking to clients about the springing, and we do discuss it as an option for all of our clients, the springing clause is best used if you do not want the agent acting if you have capacity. So, sometimes we just want to make sure that nobody's going to take that authority from us without there being an actual medical need of some sort of capacity finding. The downside with the springing clause is exactly, Jennifer, what you've identified. We can't use it. If the person has capacity, but we can't use it, it's ineffective. And we're dealing with this right now with COVID because we have clients who are in ICU. They have capacity, but they're not going anywhere. And so we're looking at their documents and we're trying to figure out how to get these revised powers of attorney into the hospital to get them signed so that the family can manage the affairs. So the capacity limitation can really be a hindrance. It can be a protection that it's not misused, but it can also be a hindrance.
When you have a simple situation, let's say, I'm going to make it overly simple, but you're basically you would set up an I love you will, right? I give everything to my wife, vice versa. If we're gone or when we're gone, it goes to our kids. We don't have any other kids from other marriages. That's it, simple as it gets. Could a person in that circumstance get away with a legal Zoom? And that also brings up then this. If you're talking about people, say, in other states, and I know on this call by the names we see that there are some people in other states outside of California, which I know is a basket case, do they, by and large, could they get assistance with that if it's a very simple, straightforward, I don't want to do anything different type of circumstance? How do you feel about that?
So the legal programs can be helpful. The key and the challenge is that the person preparing the will, the individual themselves that are downloading and inputting the information into the program, really looks at the finished result. Do I understand it? Does this make sense to me? Because sometimes I'll get these wills that they've generated from these computer programs and they just don't work. I've had clients who have the estate going to a trust. Well, then I say, well, where's the trust? And they don't have a trust. So the use of the program was inconsequential because it, in essence, made them intestate because there was no beneficiary to receive the assets. So if it's a very simple, I give it to my spouse. If my spouse isn't living, I give it to my kids, and they read the content and it makes sense to them, then sure, at least it's better than nothing. It's better than leaving it to chance. Who's in charge? What happens? And hit those key points. And make sure that you do at least have some familiarity with what the state law requires as far as execution. Most states require 2 witnesses to sign. Some states, Idaho has what's called a self-proving will. So we have 2 witnesses and a special notary. So what that will do is it's presumed valid at the time. And so as you're signing them, just make sure you're complying to the best you can with the signatures. And that's, I think, one of the problems we encounter when people prepare their own wills is, they may sign it and go down to the bank and have it notarized, but that's not valid. It has to have 2 people. So it has to have the person signing plus 2 witnesses, unless it's in handwriting. A fully handwritten will is called a holographic will. But that's the biggest challenge is, do they understand the content? Does it make sense? Does it accomplish what they think it does? And then make sure it's executed properly, because just simply, again, signing a typewritten document in all states that I know about won't be valid. Even if it's written, even if it looks like the intent, it won't be valid.
Good. That also brings up the idea that if there are complications, obviously you need to go to an attorney. How do you find one? How do you find one in another state? We're terrified here that people go out and get their attorney from an estate planning thing they saw at the senior center, which is pitching back to trusts again. And we've seen such horrible things in our time, and I'm sure you've seen worse. But people that are getting billed $15,000 or $20,000, basically what they have in their checking account is what their bill is going to be. So sending somebody off to do that in another state is terrifying. Is there an outlet in your mind or a way to do that?
So I use 2 sources, and a lot of times we encounter that same exact issue. We need to have an attorney in a specific location where we've never worked before. So I use 2 websites. One is called Superlawyers, superlawyers.com, and the other is bestlawyers.com. Both of those are peer-rated, peer-reviewed, vetted through the process. And so if I'm looking for an attorney in another state, I look at those 2 websites. And you can search by practice area, you can search by location. Generally, you'll be able to find kind of a list of people, and then from there, you can do your own research on their websites or reviews from other sources.
Great. Good.
So we have a lot of young clients that come in, usually have younger children. And I would say the majority of them do not have wills. We say you have to get one when you have minor children because you want to be sure that who you want taking care of your kids is named. What happens if, heaven forbid, something happens and both parents are killed and they don't have a will? What happens to those minor children?
So with the will, and I think, Jennifer, that advice you're giving young clients is excellent. And of course, I can only speak to Idaho. I can't speak to other states and how that would work. But in Idaho, if you have a will that designates the guardian of the child, it's an automatic. The judge just issues the order. They're given priority. It's a very simple, streamlined guardianship process because the court must grant guardianship over minor children if there's no parent that's capable. If both parents are killed or one parent's unavailable or unfit for any reason, the court has to decide. And so if there's no will and there's no designation of guardian, it's going to be whoever petitions the court. If there are competing petitions, and that happens frequently, that if we've had a minor child, it can be maybe friends, it can be extended family members. And we've had cases where we've had 3 or 4 people petitioning for guardianship, and the court then has to decide what is in the best interest of that child. And so basically it's a trial. We're putting everybody's character online. We're having witnesses. In the meantime, the court would appoint a temporary guardian, so that child may be placed in that temporary space and then completely moved in a different time. So the will for the guardianship of minors is so helpful because we know who the parents picked, and it's a very simple, direct process. So even if grandma didn't like it, chances of challenging that designation are pretty slim.
Good, good. All right, we have a question down here. It says, if you are named as trustee for someone else's trust and after they pass away, you find that you are unable or unwilling to continue being the trustee, are you able to assign a different trustee?
So that depends upon the document that granted the trustee position in the first place. Some documents will have an automatic succession. So if you are not able to serve and either you have not undertaken that job, that would be called a renunciation. I renounce the right to take on that role, or you've undertaken the role and find that you cannot continue, that would be a resignation. The trust document will oftentimes tell us what happens. Sometimes you're given the authority by the trust or the instrument to designate a successor. Acting trustee has the power to designate. If there is no successor designated or no process in the trust, generally it's a court appointment. And so the trust would be brought before the court. In Idaho, it's called a registration. So the location where the trustee is residing is where the trust is, what we call situs. That's where the trust lives. That jurisdiction, we would file a registration with the court. We would ask the court to accept the resignation of the trustee or to appoint a successor if there's a vacancy. Generally, there's a consultation with the beneficiaries or persons who are interested on who they may choose. But our starting place in any situation is, what does the trust tell us? What does it tell us about who's next in line? What powers the acting trustee has? What happens if there's a vacancy?
And just let me ask real quick, superlawyers.com or bestlawyers.com, is that correct?
Correct.
Okay.
Any other chats right now, Jen?
Yep, there's one more. Let me go here. My wife's father passed away a year ago and her mom is listed as primary beneficiary on the account, but they were divorced when he passed. In the divorce decree, she relinquished all rights to the account, but the beneficiary designation was never updated. Does she have any legal entitlements to the account as being listed as contingent beneficiary? If so, how long does she have to get it taken care of?
So if I understand the question, the spouse is named, ex-spouse is named as beneficiary, but the divorce decree gives up the rights. Most states, including Idaho, have a statute that basically divorce is treated as a revocation of any of those designations. So this is the challenge because it pits the company that holds the account with the beneficiaries or other family members. The company that holds the account has no compulsion to do anything but pay who's listed. They're not going to get into the legal fray. And at least in Idaho, our statutes kind of exonerate the institution for paying out beneficiaries in accordance with titling or beneficiary structure, paying out those benefits. So it could be that the benefits are paid out and the estate and the heirs need to sue the ex-spouse to recover those funds. So unfortunately, if there's no relinquishment by the ex-spouse of rights, no release or disclaimer, litigation is the option.
Yeah.
Unfortunately, and that we find that a lot. Actually.
Yeah. Andrew,
People get divorced and never clean it up.
Yeah, Andrew, if that didn't answer your question, please, it looks like you unmuted. Did that answer it for you?
Yeah, we were kind of worried about that because I guess on the policy, they were thinking because it said her name and then as his wife, but it's like they were saying that having that clause in there only counted when she was as his wife, but then the divorce, so it's just kind of a mess. So yeah, I think, but I think
Andrew,
that answered sort of.
I think, you know, if the company itself, usually what we'll try to do is to start with the company and present the facts, provide a copy of the divorce decree, provide any information we can to show the timing of when the beneficiary was named versus the divorce. So we usually do start with the company, but if the company says, no, we're not getting in the middle of it, we're just going to pay it according to designation, then unfortunately, again, litigation is the only option.
Okay. And then how long do we have to take care of that before, because it's still with the company trying to get this figured out, how long before it goes to like the property of the state? To deal with
unclaimed property, I don't know exactly. I want to say 7 years, but don't quote me on that. It's a fair period of time.
Okay, thank you.
Good.
Okay. Another question, pros or cons of having two executors?
So the pro would be a couple of things, balances decisions so that it takes input from two different people. Sometimes that helps with the family when you can say, well, we both agreed, so that it helps soften the blow sometimes on different decisions that need to be made. You don't have one person who's just taking the hits on all the decisions that are made. And they can allocate the duties with each other so that you take care of the bookkeeping, I'll take care of the property management. But that assumes that the individuals work collaboratively, that they talk to each other, that they are respectful for the responsibility. The downside is exactly the reverse of what I explained. They don't agree, they try to run their own way, they each try to make their own decisions, and there's really no agreement because in Idaho, a co-trustee or co-fiduciary relationship requires majority. Well, when you have two, a majority is two. So it takes both. And I've had cases where my office trust fund, we have to take all the money and hold it in our trust account because they can't even agree on what to do. And so, and I, as the attorney, can't make one of them resign or can't make one of them, be removed or have them replaced. So you have to really look at the personalities of the individuals. Will they work together? Will they respect the position, work collaboratively? Because having a co-appointment can be really helpful because you can bounce ideas off of each other. You can have some support in decisions that are made. But if there isn't that mutual respect, both parties being diligent, both parties signing documents and responding timely, it can just drag the process down.
Yeah, that's an interesting point. You're optimistic that they're going to get along and get everything done well. Many people don't want to have arguments in the family because I'm naming Johnny as the executor of this because he's the accountant of the family, but I don't want the kids to be mad about that. And so they name all their kids. And that seems like a bad idea to us. Would you comment a little bit further on that?
It is a bad idea generally because the more people, I mean, just think about even selling the house. You've got 5 kids, you got 5 people who have to sign all the closing documents, 5 people who have to sign the listing documents, 5 people who have to agree on the purchase price. And sometimes I know they don't want to have favorites or perception of favorites, but what I recommend to the clients is don't look at necessarily having individuals' feelings hurt, because what we're looking at is who's best equipped, who's best able with time availability, because if they're a busy doctor, that may be the last thing they want to be doing. Family demands, just general business acumen, who has the ability to track books and records. If they can't pay their own bills, well, we sure don't want to pay the estate's bills. So I'm really asking the client to focus on who is the best equipped. And if they're concerned about hurting feelings amongst the family, that's when I start pushing, let's look outside the family. Who do we have outside that could be a neutral person? Maybe a sibling, a brother, of the testator. So when there's concern about, well, if I name him, that person's going to be upset, then I do start kind of looking outside the family. Well, maybe let's bring in a neutral person so that we take that family dynamic of the power struggle or the hurt feelings off the table so they can have Christmas dinner together.
How about pushing for a family meeting? It's before you're dead, if that's the circumstance. I wondered if that's something you push for. We've recommended that in circumstances. Say, look, you just have to get over this. Not all three of your kids should do this. So why don't you pick one and then have a family meeting and get it all out in the open?
Dave, absolutely. I'm a big advocate of communication, because the more that we talk about, there may be different perspectives that are released during that meeting. Sometimes the parents are oblivious to maybe underlying currents that are happening in the family that they don't know about, or concerns that exist. The flip side of that is sometimes the disclosure creates more family problems and trauma, because they're putting it out in the open what their beliefs are, and sometimes it actually backfires, particularly maybe the elderly or the more vulnerable. Sometimes what we see is, and I start seeing a lot of rallying and a lot of sudden interest in the issue of the estate and the will, because they're trying to sway the person to change their mind. So it's a sensitive topic, but to the extent that we feel like a family meeting would be well received and productive, absolutely agree. But I also am a little bit cautious about maybe those people who are we know they're already going to be difficult in the family, maybe we don't.
Gotcha. Good. Hey, so we don't run out of time, though. I want to make sure we hit these two items, and then we'll answer any final questions. Does that sound good? Because these are simple, easy things that we run into and I think need to be reminders for people. Living wills, you can pick them up anywhere, right? Pick them up at the hospital, doctor's offices. Would you explain that? And then also a personal property list, especially for large families where dad promised the gun to this person here and mom said the china goes to this person, that those are very important things and often what are fought over, not the big money items. Is that fair?
Oh, absolutely. So let me start with the living will and the healthcare power of attorney. We do in Idaho have a statutory form. It is, again, state specific. So outside of Idaho, you'd have to check and see if your state has that same format. And I believe on my website, you can, I believe I've got the format of both the general financial power and the healthcare power. But if not, you can pick it up at the hospital or any location. There are two components to the living will and healthcare power. One is the actual healthcare power of attorney. That's the delegation of authority to make medical decisions. That's who makes the choices. So it's separate and distinct from the living will. It could be that you simply need a surgical procedure or you need an admission to the hospital, but you're not necessarily needing the implementation of the living will. The living will is your statutory death directive. That is going to only apply if you are vegetative or terminal to a point where no medical opinion is supporting your recovery from that condition. So it's truly, end of life decisions. The living will relates to the administration of nutrition, hydration, mechanical, artificial devices. So those two pieces are really one form in Idaho. Again, you should be able to access it in any available medical hospital resource. Check my website. And even call. If you can't find it, call. I'll email you the form because we give it away readily. It does not need to be notarized. It does not need to be witnessed. So I recommend that you have a witness just to validate they saw you sign it in the circumstances, so we don't think you're like tracing the window, you know, the signature on the window. So I recommend it be witnessed, but our current statutory form does not require witnesses or notaries for the living will and the healthcare power of attorney. The property list, absolutely important, particularly for those families that do have a lot of mementos or items or things that are close to the heart of the family, for lack of a better description. And as you say, they're oftentimes not monetary. There's nothing that's terribly valuable. I just fought a whole battle for the last year over barbershop antiques that probably were less than $2,000. But two attorneys, you know, we had to make sure that those barbershop antiques got divided appropriately because it was important to the family. It had nothing
It turned into a lot more valuable than $2,000 or more costly.
Yeah, that's right. We had the attorney time and they're very priceless. The written statement or list is something that you can just prepare in handwriting. Type it up, date it, sign it. Whenever we're preparing documents informally, so not through the attorney's office, the benefit of an attorney is we can validate what we sent you, what we saw you sign, what we talked about. So it's kind of a third-party collaboration. If you are preparing documents on your own, such as these handwritten statements, you can type it and sign it, but the risk is the argument is made that you didn't prepare it. Somebody else prepared it and kind of forged your signature. And it's much harder to validate a signature than it is an entire handwritten document. So for tangibles, putting it in your handwriting helps us because we have a bigger handwriting sample if there is a dispute about the validity of that document. So for the tangible items, you are going to identify the item with enough particularity we know what it is. So if you have 10 bases, you need to be a little more specific. You need to identify who it goes to, date it, sign it, and keep it with any other original estate planning documents that you have. Again, if you have an attorney, share it with the attorney. So that way that individual can say, yeah, I got this from the client on this day, and there's tracking. So in my world, it's all about proof. What happened when, who prepared it, what was the timing? And so the more that you can either make the family aware of it, make your attorney aware of it, make sure it's notarized or handwritten so that we can somehow validate that it was a properly executed document. It's very helpful to help, you know, to just give us a guideline of what you want. So if it's important to you, write it down. And in today's world, I actually have clients who are taking digital photographs of items because they can take a picture of the ring, they can take a picture of the watch, and then next to it, they'll write who gets it. So that's another option.
Good. Why don't we finish with a couple questions and wrap it up here, Jen?
Yep, I think one of them you kind of answered when you were talking about the handwritten list. It sounds like it is the same with the handwritten will. The question was, are any issues with handwritten wills? It doesn't appear to be from what you just said about the list. Is that correct?
So a handwritten will in Idaho is valid. It is called a holographic will. All of the material provisions need to be in handwriting. So that's one of the keys. Don't type it up and then sign it. That won't work. But again, if you handwrite the entirety of the will, sign it and date it, it is a holographic will. The key on any document is make sure you understand what you're saying. Because again, we get into disputes about what does the word mean. I had a case one year that was, I give all of my CDs to Jane. Well, are CDs certificates of deposit or compact discs? So the person knew what they were saying, but we didn't in interpreting it. So that's the risk of preparing the documents yourself, is just make it as clear as you can, because it may not play out clear to somebody else.
Average cost of probate, I know that's a hard one. We had it from a client that lives in Virginia, but do you know a range?
Well, in Idaho, I would just, again, I can't speak to other states, but Idaho, I would say probably $1,200 to $1,500 for a probate. That, again, that assumes no disputes, no issues, everything just transfers, and we have an undisputed process.
Okay. And the last one, this one may be a little more detailed than we can trust here, but we'll try. We are retired, have a young adult which is autistic. We don't want to leave a sum of money. Wouldn't a trust be warranted in this situation?
So with a child, any individual that has a disability for which government benefits are being paid, Medicaid, Social Security, disability, those are absolutely appropriate times for a trust. And if they are receiving governmental benefits, it would be what's called a special needs trust. And that trust is very refined in term, and it's intended to not disqualify the individual from governmental benefits. So certainly, what we're looking at in that context would be, even without governmental benefits, what sort of controls would be appropriate to make sure that that individual's needs are met without necessarily putting those funds directly into the individual's control, but putting somebody there who can help monitor the funds and take care of any costs and expenses and other needs that individual has. But that type of trust, again, could be set up in a will. So we would have a will that distributes to the special needs trust. So a revocable trust isn't necessarily needed, but it's the trust directing assets to that child that can be created either through a will or other mechanism that's important.
Okay, they added this, no disability. He's doing fine, but very gullible.
Mm-hmm. Still a trust. I still think that's a wise purpose for the trust. I look at the trust as kind of protecting people from themselves. And even though you look at young adults, they're perfectly legally competent. They're over the age of 18, probably very intelligent, but young adults just make rash decisions, or they're influenced by their friends. And I look at the trust as a means to protect the individual from themselves, to make sure that those funds are there to care for them, to provide food, shelter, needs, education. But that goes to make sure we have a good trusted person who's going to manage as trustee those funds.
Good.
Perfect.
Sandra, thank you so much. We
Yes.
sure appreciate lots of good information there for sure. And I did, folks, if you have any other questions, you can shoot them to us. You see Sandra's email, I should say, website out there if there's something in general you want to download a form. But anyway, we appreciate everybody tuning in. I want to mention this real quick. If you want to review it, up in a day or two, it will be there on YouTube, correct?
Yes.
All right, good. And that I wanted to get confirmation it will be there in a day or two. We also, of course, have lots of others that people have asked for in the past, and we see by the views that people are starting to catch those. So join us there. And also, finally, this weekend, I'm going to take a break from the radio show, and so that's going to be yours. What are you going to talk about on Saturday, Jennifer?
Oh, we're going to make it a surprise. No, we did a cute story a couple of years ago. It's our Christmas story, so we thought it was very cute. We're going to redo that again. I believe Tom Brown will be joining me too, so it should be great. We look forward to it. So thank you for letting us do it, Dave. And Sandra, thank you so much. This was awesome.
Thank you, Jennifer and Dave.
Thank
Happy
you.
holidays.
Happy holidays, everyone.
Merry Christmas.